Here's a question that's keeping tech lawyers awake at night. What happens when one of the world's most powerful AI companies gets accused of hiding evidence from a judge in a billion-dollar lawsuit? That's exactly what's happening right now. The New York Times legal team just publicly alleged that OpenAI deliberately concealed documents, data, and communications during the discovery process of their copyright case. Discovery is supposed to work like this. Both sides show each other all their relevant evidence so the judge gets the full picture. But the Times is claiming OpenAI actively withheld crucial information about how ChatGPT was trained and how the company handled copyrighted material. This isn't some minor procedural slip-up. Evidence tampering during discovery can get cases dismissed, companies hit with massive sanctions, or judgments overturned on appeal. We're talking about a company that's reshaping how millions of people interact with artificial intelligence, now facing accusations of playing games with the legal system. The stakes here extend way beyond OpenAI's courtroom battle. If these allegations stick, they could reshape how AI companies operate, how regulators view their trustworthiness, and what legal precedents get set for the entire industry going forward. So what exactly is OpenAI accused of hiding? And what could the consequences be? To understand why this evidence allegation is so damaging, you need to know the background of this case. The New York Times sued OpenAI back in December of 2023, claiming that the company used millions of their copyrighted articles to train ChatGPT without permission or compensation. Think of it like this. Imagine a company photographed every book in a library, scanned all the photos into a computer, then built a machine that could summarize or rewrite passages from those books. The Times is saying OpenAI did exactly that with their journalism. They're asking for billions of dollars in damages. This isn't the only copyright lawsuit OpenAI faces, but it's one of the highest profile ones because the New York Times is such an established, powerful media organization. The case involves fundamental questions about what counts as fair use in the age of AI. Can a company train an AI model on copyrighted material if the goal is to create a new tool? Or does using someone's creative work without permission always require compensation? These questions matter because the answers will determine how every AI company builds and trains its models going forward. The discovery process is where both sides are supposed to show their cards, to let the judge see exactly what materials were used and how the training happened. That's why the allegations of hidden evidence are so serious. So what specifically is OpenAI accused of hiding? According to the Times allegations, the company failed to disclose certain documents and data that directly relate to how they use copyrighted material in training ChatGPT. The Times claims OpenAI withheld information about their data collection processes, how they filtered training data, and communications between executives about using copyrighted content. Think about it this way: if you're trying to prove someone made a copy of your book, the most damaging evidence would be finding their notes about which copies to make and who authorized it. That's essentially what the Times is looking for. The allegations suggest OpenAI didn't provide complete records of their training datasets, potentially including logs, of which News Times articles were included. They also allegedly failed to produce communications about copyright policy decisions. In legal terms, this is called a discovery violation. It's when one side deliberately or negligently fails to produce evidence they are supposed to share. The seriousness depends on whether it was intentional hiding or just poor record keeping, but either way, courts take this very seriously. It's the foundation of the entire justice system. Both sides have to be honest about what information exists. When that trust breaks down, judges can sanction companies, exclude evidence at trial, or in extreme cases, fine them in contempt of court. This is where the case potentially changes from a copyright dispute into a legal ethics scandal. Let's get concrete about what this looks like in practice. Imagine the judge ordered both sides to produce all documents related to OpenAI's training data for the past 3 years. OpenAI's legal team is supposed to search their servers, find every relevant email, every dataset list, every communication about copyright, and hand it all over. The Times' argument is that OpenAI didn't do this completely. They claim OpenAI provided incomplete datasets, failed to produce certain emails from key executives about training decisions, and didn't disclose all their sources. In one example, The Times might have found evidence that OpenAI was explicitly aware they were training on copyrighted material from major publications, including The Times itself. If OpenAI knew this but didn't initially disclose it, that's a problem. Another example could be that there are internal policies about copyright that weren't produced initially. Discovery violations often come to light when the opposing sides, lawyers, stumble across something later and say, "Hey, why wasn't this provided 6 months ago when we requested it?" The Times legal team apparently found gaps and inconsistencies in what OpenAI provided. This is how these cases unfold. Lawyers compare what they get against what should exist. And when something's missing, they raise it to the judge. The court then has to decide whether it was innocent negligence or deliberate hiding. And here's the kicker: if the judge decides it was intentional, the consequences can be severe. This isn't the first time a major tech company has faced discovery problems during litigation. There's actually a playbook here, and previous cases show just how badly this can go wrong. Back during the antitrust trial against Microsoft in the late 1990s, the company's discovery violations actually damaged their credibility so much that regulators pushed harder for a breakup. When companies get caught hiding evidence, judges don't just let it slide. They use it as proof that the company can't be trusted. The Standard Oil case in the early 1900s involved similar issues with document production, and it influenced how strictly courts now enforce discovery rules. More recently, Facebook faced discovery issues during various regulatory investigations where they failed to produce certain internal documents about user data. Each time, it strengthened the case against them. The pattern is consistent. Discovery violations make judges skeptical about everything else the company claims. If OpenAI says, "We didn't intentionally use your copyrighted material," but they are caught hiding documents about how they source training data, the judge is going to wonder what else they're not being truthful about. This is why the Times allegations are so dangerous to OpenAI. It's not just about one lawsuit. It's about establishing a pattern of untrustworthiness that could affect regulatory decisions, future lawsuits, and how the public perceives the company. In tech litigation, reputation and credibility matter almost as much as the legal arguments themselves. Why does any of this matter to you? Because this case is going to set the legal standard for how AI companies can use data going forward. If OpenAI wins despite the evidence allegations, it sends a message that AI companies can push boundaries in discovery and face minimal consequences. If the Times wins and the evidence violations stick, it could lead to sanctions that make the lawsuit even more expensive for OpenAI. You're potentially talking about millions or even billions of dollars in damages, plus attorneys' fees, plus reputational damage. But there's a bigger picture here. Every AI company building a large language model has had to grapple with the copyright question. How do you train on the vast internet without getting sued? OpenAI's handling of this case tells every other company whether they can risk doing the same thing. If OpenAI gets away with hiding evidence, others might too. If they face harsh sanctions, it sends a stronger message. The regulatory implications are equally significant. The FTC and other regulators are watching this case closely. If they see that OpenAI concealed information from the court, it strengthens arguments for stricter oversight of AI companies. It could lead to mandatory data audits, public disclosure requirements, or even restrictions on training methods. This case could reshape how AI companies operate at a fundamental level. It's not just about one lawsuit. It's about establishing the legal and regulatory framework for the entire AI industry for the next decade. So what's actually going to happen as this case moves forward? First, the Times has to formally present their allegations to the judge, usually through written motions. They'll argue that OpenAI's discovery violations were either intentional or grossly negligent. OpenAI's lawyers will respond with their own filing, explaining why the documents weren't produced. They might claim the records didn't exist, were lost in a system migration, or that the Times didn't properly request them. The judge will then decide whether the violations actually happened. If they did, the next question is the remedy. The court has several options. The mildest is ordering OpenAI to produce everything they should have provided in the first place. But that's if it wasn't intentional. If the judge thinks it was deliberate, they can impose sanctions, monetary fines, excluding certain evidence from trial, or even finding the company in contempt of court. In really serious cases, judges can issue a default judgment, meaning they automatically rule in favor of the other side without even hearing the full case. The judge could also instruct the jury that they should assume the hidden evidence would have helped the Times case. These are powerful remedies, and they stack on top of whatever happens with the main copyright claims. The timeline matters too. This discovery dispute might take weeks or months to resolve, during which the main trial could be delayed. Every delay means more legal fees, more pressure on OpenAI, and more opportunity for the Times to pursue other angles. Here's what this whole situation really comes down to. When massive companies operate in new territories with fuzzy legal rules, transparency matters more than anything else. The copyright question in AI is genuinely complicated. Reasonable people disagree about whether training on copyrighted material counts as fair use, but hiding evidence during a court case, that's not complicated. That's unambiguous. And here's what this means for you as someone who creates content, uses AI, or just cares about whether big tech companies follow the rules. If courts decide that OpenAI tried to hide evidence, it strengthens the case that other companies should be required to be more transparent about their data sources. It could lead to regulations requiring AI companies to disclose exactly which copyrighted materials they used for training. It might eventually mean you get compensated if your content was used to train an AI model. This case is essentially deciding what the relationship between AI companies and creators looks like for the next decade. Watch for the judge's ruling on the evidence allegations. That's going to tell you everything you need to know about how seriously courts are taking this issue. Subscribe for updates as this case unfolds, because the outcome is going to ripple through the entire tech industry. Follow for daily AI news.